It's a third.
Mark Garcia.
The punishment range is that of a third-degree felony in that one, which is between, if you're found guilty, between 2 years and up to 10 years in prison. Do you understand? And then in cause number 24, DCCR 1349, you're charged with theft of property. Which is a state jail felony, and that's from May 18th of 2022. And then what that means is if you get found guilty in that case, the range of punishments between 6 months and up to 2 years in a state jail prison. Do you understand? In each of these cases, I have plea bargain rejections here with your signature on them and Mr. Galmore's that shows that the district attorney's office has made offers if you wanted to enter a plea of guilty in your cases. In the violation of relating to hazardous waste, they've offered, it looks like, is that a 6?
Oh, no, I didn't put the year, sorry, Judge. It was short.
Calmore.
The deal was for a short term of deferred probation.
So it's for a deferred probation that would be up to me, and I guess, which is obviously you've gone over with Mr. Galmore, type of probation where you don't have a felony conviction on your record. And then, is it the same in the other case? So you would be, if you wanted to plead guilty, it would be deferred probations in each of those cases with the term and how long that probation is up to me with input from everyone, of course. You have every right to reject those offers and have both of your cases set for trial. I do want to make sure you understand that what your possible consequences are if you go to trial, what your options are if you wanted to enter into those agreements. And do you understand all of that? And do you want to reject those agreements and have your case set, both cases set for trial? All right, and is there any reason, I mean, obviously, I can't imagine that the offer would get better. Ms. Malfino?
It's a Mr. Shearer's case, Judge. I don't have any reason to believe that that offer would change. I know they've discussed it for quite some time. I want to
Yes.
make sure if it's on the trial docket that he's prepared to read.
So I do typically make sure, unless there is new evidence that comes up that either Mr. Galmore or Mr. Shearer does not know about, or something has changed, I will not accept these plea agreements after today. And so if you change your mind later and want to enter a plea of guilty, it would be to some other plea agreement or open to the court or something like that. Do you understand?
Judge, just for the court's perspective, this case had a restitution in the amount of approximately $100,000. That's been reduced to approximately $13,000 now that those financials have been sorted correctly.
Okay.
I believe this is a situation where it either require trial or it would be dismissed for restitution.
Okay, so not a restitution paid out over probation. Okay, all right, then obviously if that happens before, then the cases get dismissed, and that's another way for them to get off the trial docket. But other than that, we'll let a jury decide. All right, you're free to go. I'll set it on the trial docket. Thank you.
Drayton Rose.
Got Rose? You just called Rose?
Over there. It's a different one. James Rhodes for you.
I'm sorry.
James
That's a
Rhodes.
dismissal.
Judge, may I just set that on the record?
Yeah, do you have a dismissal on that?
I don't.
Oh, not yet. Okay. Is he here?
No, he's actually, he's late, but I found out they're gonna dismiss today.
Okay.
Judge, I just would like to put on the record, if I may, Mr. Rhodes is enrolled and doing very well in the Veterans Treatment Court. That docket will be in 2 weeks. I'm going to go ahead and dismiss the case today. He has progressed nicely through that program. Just wanted to put that on the record due to the nature of the case.
Sure.
I don't have any information indicating there's been any issues between he and the complainant in this case. So
Okay.
with the court's permission, that way he can try to get his job back now with the dismissal, with
Sure.
the understanding that if he doesn't complete the case,
Okay, thank you. I'll sign it when it comes through. You can go ahead and let him know if he's on his way that he doesn't need to come in.
I will, thank you, Judge.
You got Norbert Freelo Jr.,
Yes.
25 DCCR 0366. Good morning, sir. You're Norbert Freelo Jr. And Mr. Freelo is charged with murder, and Mr. Galmore, Mr. Nichols, what's the announcement?
Judge, I don't think we're ready to set this for trial yet. I know it seems like every hearing I tell you there's stuff we need to investigate and find out, and there is still in this case. There's a potential witness who has given unsworn statements that is basically blown off appointments to give a sworn statement, and we need to run her down.
That's what we were gonna do last time.
And they made appointments and she didn't show up.
Well, if we're talking about that one witness, she did meet with the investigators between,
Okay.
but there's also a new witness, another
Oh,
witness.
another,
now,
okay.
And possibly some video footage that was deleted that I believe that Port Arthur Police Department is trying to get their hands on.
I need to check the status of the subpoena for that video. We need a little more time to it.
Okay, all right, we'll just do a normal reset. Y'all can work on that. We'll see where we are at the next
Thank
court
you.
date. Mr. Freelo, make sure you stay in touch with, did you have something
Yeah, I
else?
could, yes, Judge. I don't have a motion necessarily on file, but Mr. Freelo currently is on house arrest with a GPS device. His wife is recently been unable to return to work to the federal prison, so their income is limited. He's trying to find a job. It's been difficult, obviously, with the thing hanging off of your ankle and whatnot. So we were asking the court if the court would consider removing him from house arrest and GPS requirement.
No to both of those things, but potentially to, the GPS is gonna remain on. I would consider, Mr. Nichols, what's your position with regard to him looking for work and getting a job?
I'm in favor of that, Judge, but I agree with the court. I think the monitoring needs to stay in place.
For now, at least, you know,
Monitor removing from house arrest? Okay.
yeah. Wear long pants and cover it up, you know, I mean, whatever you need to do. But at this point, I'm not willing to do that based on obviously the nature of the offense. And so if you do this, Mr. Galmore, if you'll just send maybe a memo over and copy Mr. Nichols on it so that I have a paper trail to say that you asked me and that I granted that part of it, and I'll just sign off on a memo. It doesn't need to be a motion.
We'll do
But
that.
that'll just remind me to get it in the file so that it's clear. Also, we can send that to whoever has his GPS monitoring device, so they know it's just for work-related purposes. You can go find a job, go to work, things like that, but it's not just a full-on go do whatever you want kind of
Well, Judge,
release.
actually, that's currently the status. He is allowed to leave only for work purposes currently. But because his wife is unable to work, her medical conditions made it much more difficult for them. So if the court would still consider just removing him from house arrest and keep the GPS, that would probably help a lot with the other life's necessities.
Okay. I know you've asked for him to drive her to this, there's been
Yeah, he had to take
doctors
him to the
issues.
airport the other day. But I mean, obviously in life, a lot of things like that pop up regularly, and if he's gonna wear a GPS device, you know, the court will always know where he's at if that's important. But removing him from house arrest would be probably a big help.
Mr. Nichols?
Hard for me to really argue with that reasoning, Your Honor.
Okay, so I am going to require for you to remain in Jefferson County without permission. So if something happens, like the other day with the trip to airport or whatever, get with Mr. Galmore, he'll send me something, I'll approve or not approve. In Jefferson County, do what you need to live your life. I don't want, I mean, that doesn't include going to bars or going out at night
Maybe a
or.
curfew is appropriate, Your Honor, unless,
Yeah, that would be,
I mean, if he ends up with a night job, obviously, that's different, but.
so let's do this for now. Let's make a, I'll release the house arrest, remain in Jefferson County with the curfew 8 p.m. to 6 a.m. If you get a job that interferes with, just get with Mr. Galmore and get those hours, whatever the job is, and we'll work around that. But primarily, I want you doing necessities away from your home, and that's it at this point, okay? All right,
Thank you, Judge.
thank you.
Thank you, Your Honor.
One more. Brandon,
Yes,
sorry.
Brandon Broussard. Yes, ma'am. Okay. Good morning, sir. You're Brandon Broussard. And this is 24 DCCR 1150. Mr. Broussard's charged with aggravated assault causing serious bodily injury. Mr. Galmore, what is the announcement?
Judge, we're asking for another announcement day just to continue go over any of the evidence and getting with the state, see if we can resolve this without putting on the trial docket.
All right, looks like you've been on since June. I'll do one more. Mr. Broussard, you need to make sure, stay in touch with Mr. Galmore. Y'all go over everything. Because at that next court date, we need to get an announcement whether or not this is going to be a trial or if it's going to get worked out, okay? All right, we'll see you at the next court date.
Thank you, Judge. That's all I have.
Thank you. See, is Mr. Frazier? guess, Mr. Roebuck knows, I guess this is getting dismissed and doesn't need to come back down.
They went down the hall and took care of
Okay.
the motion, Your Honor.
Okay, I'm signing that dismissal now. Mr. Jeffries, you have Stephen Hayes.
Yes.
Mr. Hoffpower. Morning. How are you?
I'm here.
It's Monday.
Yes, ma'am. That is fact.
Morning. All right, good morning, sir. You're Stephen Hayes. And Mr. Hayes's cases are set for trial to begin with jury selection next Monday. What is the announcement?
State your. Ready?
All right, any negotiations or anything we need to talk about that anything's changed? It will very likely be the number one case due to the nature of the offense and the age. And so if anything changes with any negotiations, really need to know by tomorrow when I set that trial docket tomorrow after docket. Stay in touch with Mr. Jeffries, and if so that we know if anything changes, we'll get that taken care of this week. If not, we'll see y'all next Monday.
Yes, Your Honor.
All right,
Thank
free to
you.
go. Thank you. Where am I? See, Mr. Comerford, on Ronnie Oliphant,
Yes.
and this is Mr. Coleman's case. Morning.
Good morning.
Good morning, sir. You are Ronnie Oliphant, and in 25 DCCR 0379, Mr. Oliphant is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
We were just asking for another reset date so we can have more time to investigate.
Any issues that you see notated? All right, looks like you guys were hired at the end of July. I'll reset it another time to give you some time to try to get all that discovery and evidence taken care of. Mr. Oliphant, make sure you stay in touch with your attorney so you guys can go over everything, what your options are. We'll see if we can get an announcement at that next court date.
Thank you, Judge.
All right, you're free to go. Thank you.
Simon Gobert.
Do you? Mm-mm. Yeah, I don't see him on the docket for some reason. If you'll just check with Ms. Holmes, she'll.
Simon Gobert. G-O-B-E-R-T.
Huh? Oh, where?
Is it on there?
Oh, are you here for Mr. Flory? We have Mr. Flory listed.
Oh, it's me. My office did file notice of appearance.
Oh, maybe
Yeah, it's on the docket. It just has a different name. Let me look here. Yeah, thank you. So do we need to change you to
Yes.
primary? Okay, Simon Gobert?
I apologize.
Good morning, sir. You're Simon Gobert? And in 24 DCCR 0512, Mr. Gobert is charged with the second-degree felony offense of attempt to commit sexual performance by a child. What is the announcement?
Defense needs more time to review any potential plea offer.
We've given an offer, Your Honor, he's got to discuss it with his client,
Okay,
so I believe one more recess.
one more should be good because it looks like you were hired, this was from June. So yeah, this will be the last reset. Make sure you make an appointment, go visit with your attorney. You know all your options, and when you come back, it'll either be taken care of with a plea or moved to the trial docket with a rejection, okay? All right, you're free to go. Thank you.
Thank you, Judge.
Mayor Pro Tem?
Yes, ma'am. Let's see. Let me find you on here again.
He's on the last page.
Okay. Did you just say the last page?
Maybe it's page 5. What's the?
Oh, I'm looking at,
Spikes.
sorry.
Page 5.
Okay, here we go. Ms. Hawkins on Devon Spites. Good morning, you're Devon Spites. And in cause number 25, DCCR 0023, Mr. Spites is charged with theft of property, and what is the announcement?
Judge, we had one last outstanding piece of discovery I just received this morning,
Okay,
so if we can have some time to review it.
all
I'll
right,
be sure to visit. I think there was just a miscommunication on that thumb drive, so we gave her a copy this morning.
Okay.
While she was already here, since she made the drive, and we'll be sure to talk about it before next Saturday.
okay. So, Mr. Spites, make sure you stay in touch with your attorney so that before that next court date, y'all can go over all of the evidence that she's received in discovery, and we need to get an announcement at that next court date.
Yes,
All right? All right, you're free to go. Thank you.
Thank you, Judge.
Sure. Let me get to it. Juan Martinez, cause number 25, DCCR 0401.
Your Honor, he is a Spanish speaker, if I may translate for him.
Yes, sir.
With permission.
Yes, thank you, Mr.
Thank you.
Peraza. And sir, you Juan Martinez?
Yes, ma'am.
And Mr. Martinez is charged with assault of a peace officer from March 23rd of 2025. And what is the announcement?
Judge, on this one, we would ask for a reset. Spoke to Mr. Peraza this morning, and I want to go back and look at the body cam video.
Okay.
before we proceed.
Okay, so I'll do just a normal reset, which is about 30 days.
Thank you, Judge.
And that'll give Mr. Smith to go through that, get back with you. And Mr. Martinez, make sure you stay in touch with Mr. Peraza, so you guys can go over everything that he receives and know what your options are when we come back. Okay?
Yes, Judge.
All right, thank you.
Thank
You're
you,
free to
Your
go.
I'll send you electronic. Thanks a lot. Appreciate it.
See. So there. Mr. Paget, looks like you have Catherine Castillo,
I do, Your Honor. So Phillips case.
2 cases. Good morning.
How are you?
Good, how about you?
Excellent. Ms. Castillo, sorry, I didn't see you up on.
Good morning, you are Catherine Castillo, and Ms. Castillo has two cases. She's assault of a peace officer and then also driving while intoxicated, third or more, and what is the announcement?
Your Honor, we need 30 days. I've received all the discovery. We're going to review the video evidence. I have an offer now. I'm going to relay that to her. We'll meet before we come back, and the case will be disposed of on that day.
Okay, this will be the last for an announcement. Ms.
Absolutely.
Castillo, make sure you get with Mr. Pageant. Now that he has everything, you guys can go over all that discovery, see what your options are, and we'll take care of your case at the next court date. Okay, you're free to go. Thank you.
Thank you, Your
Mr.
Honor.
Pageant.
May I be excused?
Yes, sir.
Thank you. Thanks for this.
Yeah. Mr. Frazier, you've got Edwinia Johnson, so sentencing.
Yes, Your Honor.
Good morning, you're Edwinia Johnson? And Ms. Johnson was previously in court, entered pleas of guilty in all three of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor, yes, Judge.
Are there any additions or corrections?
I'd just like to address one thing that Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think. And I'll ask my client to clear it up. Now, you're working for a home health care agency, is that correct? And
Answer yes or no, please.
And your client at the time had asked you to dispose of some personal banking checks, is that right?
Yes, and I took them. I misspoke. I meant to say I took the checks, and I knew that Adrian Hayward was gonna cash them, so I'm just as guilty as him.
Of the four.
So, and she said in here that she's the one who took them.
Yeah.
So I'm
Mr.
okay with
Smith
that.
brought it up, and
Okay.
I wanted
I had an
to
issue
clear up
with her taking
culpability.
responsibility.
I appreciate that. Yeah, I
And,
agree.
they've never caught AJ.
No, I've been hearing that he's incarcerated or whatever, but I haven't been around.
Okay.
Thanks.
Any other issues?
No, Your Honor.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shelton, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss them, but I didn't have paperwork on probation.
Okay.
Um,
What,
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the, won't abandon and get some of the CPS rules. I didn't see that.
well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
The plan is
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and they,
We can go talk to Judge Shelton maybe, or no, is this is fine?
no, I mean, that's as long as but she's gonna have to give her probation officer documentation from CPS. So you can work that out with your probation officer. So mine's gonna be no unsupervised unless, and then if
yes,
probation
okay.
gets that information and she's doing her safety plan and everything, then we're gonna be okay with that here also. But they're gonna kind of be the ones that dictate that process, not me.
Just kind of nebulous. Couple conversations with appointed counsel on that, and a couple conversations with the caseworker.
Okay, all right, so
Get
Ms.
this
Johnson.
done is what he told me, so.
Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity, because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right? Good luck to you, ma'am. Thank you, Mr. Frazier.
Thank you.